All right, so this morning's speaker, we're going to do today a little bit different than we did Tuesday, because as much as I did learn a lot of things on Tuesday, I didn't get to ask any of the questions that I had for a federal judge, and I had a lot of questions that I wanted y'all to be able to hear the answers to, and you may have had some as well. So I'm going to introduce our speaker, and if she has anything that she feels that she really wants to get off her chest this morning, she can say that first. But then we'll just jump right into questions. So I hope you'll have some. And I've got a bunch too, so we can start off that way. But I want to introduce to you Judge Amy Walters. She is a CSU graduate from 2001. She then went to New Orleans School of Law, where she graduated in 2004. She primarily practices in the area of family law, and she has, I would say her primary practice is in representing the interest of children in cases throughout the court system. So not just in like divorce custody cases, but you'll often find her also representing the interest of children in probate cases where a child's parents may have passed away and they need some sort of representation regarding their parents' assets, or a person is incapacitated for one reason or another and needs representation. So she's very experienced, and I will also add, extremely well regarded and respected in the field of child welfare law. So we're lucky to have her to speak on that this morning. And even though that doesn't necessarily directly impact the discussion of business law that we've had for the semester, I do think that it's interesting, and you can see other aspects of things that we've studied through what she'll talk about in some of her own experiences and own stories. She also serves as the Associate Magistrate Judge in Muskogee County. So I'm going to pull up while she's talking the chart that we used at the beginning of the semester that showed the state court system. So Magistrate Court is a trial court, so it's an entry-level court, and they handle a lot of what we would think of as small claims court. So y'all are too young to remember the People's Court and Judge Wapner and things like that. I'm not too young for that. And so she handles a lot of those issues. She handles a lot of landlord-tenant stuff. And I'm going to let her tell all about that as well. She was kind enough to give up her time to come and do that this morning, and plus I bribed her with some fine bourbon, and which usually works. And so here she is. So y'all help me welcome Judge Amy Walters.
Okay, so I am not a lecturer like Judge Howes, I understand, was, and gave you a history, because I don't know it. So, what do you want to know?
Talk to us, Amy, about, start off, because we're interested in what judges do and, kind of what your job as a judge is. What do you see in your court?
All right, so magistrate, and we have a magistrate court here and a municipal court here. Not every county or every circuit in the state has that. So when if you are arrested in Muskogee County, and you were arrested by the Sheriff's Department, or you were given a ticket from Georgia Natural Resources, it's like boating or hunting without a license, then that comes through the municipal court. So we have preliminary hearings, Monday, Wednesday, Friday at 9 a.m. in the municipal court of Muskogee County. We moved them to like a hybrid virtual when COVID started. So if you're arrested and you're still at the jail, you're on a screen, and we have a preliminary hearing. You see these all the time in recorder's court and police department. So if you're arrested by CPD, you go, or just CPD, you go through recorder's court, which is our city court, and that's Monday through Saturday. They have recorder's court hearings. So if you're arrested, municipal court, you have a probable cause hearing. If you are entitled to a bond, you can plead guilty to certain things there, misdemeanors only, misdemeanors and traffic offenses. If you are found to have probable cause for a felony, in our circuit, it gets found over to Superior Court. If it is a misdemeanor, it gets found over to State Court. If you have a mix, the higher prevails, so everything goes up to Superior Court. So that's the kind of the criminal part that we deal with. We also deal with kind of small claims. You think of people that I'm suing my, contractor because he didn't fix the house exactly the way I wanted to. In Georgia, we have a $15,000 cap for those courts. So you can sue for any amount, but if it's over $15,000, it has to go to a higher court. It's $15,000 and under, it goes to our court. And people sue for all kinds of things, because you can. Because it doesn't tell you you can't file this lawsuit. We had a blessed sweet woman who keeps like filing suits against her landlord, but there's like nothing to them. She's just got a little bit of dementia, honestly, and so she like goes down to the courthouse and files these kind of random lawsuits, and then the landlord gets served and they show up for court. She never comes to court. Never. She files them and then doesn't show up. She like pays it's like $80 to file a case and never shows up to court. To the point where we had to actually issue an order that says you have to get court approval before you can file any more suits against this person because you keep filing them and you don't show up.
Is that legal?
Sure. Yeah, a little bit. We let her do it. She just kind of has to like go through a step.
Gotcha.
We do in municipal magistrate do dispossessories. So that is a fancy term for eviction. So we do thousands of evictions every year in our court. You've got two kind of ways you can do it. They have something called tack and mail, which literally means what it says. You file an eviction, I'm a landlord. You have not paid your rent. But I don't even care that you didn't pay your rent. I just want you to go. Like you've been an annoyance, you have parties, I just want you out. You don't pay so rent, perfect, there's a good reason. I file an eviction, literally it is tacked to your door, hence the tack part, and then it's mailed to you. You're not served by law enforcement, it's tack and mail. When you do it that way, there's really not a whole lot of defenses to it. You can file an answer. Once the person files an answer, when you do it as a tack and mail, it is saying, I don't want any money from you, I just want you to go away. I want you to get out. If they file an answer, it changes the case and then becomes what we call a money judgment case, meaning, well, now it's a question of how much money do you owe? And they have to pay. When we have dispossessory hearings on any type of eviction, there's kind of two options. One, we can make a person pay into the court for usually 2 or 3 months till we have another hearing. So you have to pay into the court registry your rent, what your back rent, and like your rent timely on the first day of the month by 12 o'clock p.m. until you have a court hearing. And if you miss a day or you're late, it's an automatic issuance of the eviction notice. Or we have like other hearings that determine how much you just owe as a whole, and you're going to get out within a certain amount of time, and you got to pay this money. So we have, when we have some of these hearings, we have what we call 7-day holds on them. So if, you filed an eviction against me, I owe like 3 months rent. And we get to court and I'm like, I don't have the money. I'm not gonna be able to pay you the money. I don't have the money. The judge can issue an order saying, well, I'm finding that you owe the money. And that's sort of a judgment, I guess, against you. It is a judgment. But you also got to get out of the house. But because you showed up and made an attempt to not just run away, I'm going to give you 7 days. We call it 7-day hold. You have 7 days to get out of the house with no law enforcement coming in. No, the landlord can't come in. You have those 7 days to get all of your personal property out of the home. But on that 8th day, we say we have a lot of these on Tuesdays. So we say until Monday at midnight. So Tuesday morning, if you're still in that house and you were just not going to leave, the landlord can contact law enforcement, set it up with the sheriff's department to come out there and physically evict you. Now, I will, not going to lie, for years before I dealt with this court, I always thought that law enforcement came and took your stuff out of the house. That is not true. Law enforcement literally stands there while the landlord takes the stuff out of the house, if your stuff is all still there. Law enforcement is just there to make sure that there's no damage to it, that they're not throwing things and breaking them if you're actual property. And if you, as the tenant, are actually still in the house at that time trying to move your property, the landlord's there to try and make sure that, the law enforcement's there to make sure there's no kind of issues between the landlord and the tenant, which can happen at times. So we are here. And there are, appeals from our court, which are not often, but happen every now and then. for small claims cases do go up to Superior Court and then kind of process through here. We don't have a lot of appeals. We have a lot of people who say they're gonna appeal and they don't appeal. Like for example, I had a hearing with a guy. We do a lot of debt collection. You don't pay your credit card. And you just stop. Like you own a Discover card and you stop making your payments and you owe like $10,000. And they call it a charge off, which is when they say, you're clearly not gonna pay us, so we're gonna kind of close the card out. Then they sue you for the money. And sometimes it takes a long time to get to that point. What they do is they will sell off the debt to a third party company, like just larger companies, and then those companies have lawyers, these large firms that do nothing but this all over the country, that then file these suits. So I had a guy, it wasn't a credit card, it was a debt though, who had an ambulance bill. And get to court, attorney for the company that owned the debt now was like, here's all the information, here's the bill, here's all the stuff, he just won't pay the bill. And the guy kept telling me, that's not me. I was like, okay, all right, well, legit, that happens every now and then. So, all right, well, here's the records from the ambulance ride. Well, sir, is this your social security number? I didn't say it all out loud, but I said the last four. Yep. Well, is this your home address? Yep. Is this your phone number? Is this your doctor's? We went through the whole list. And he was like, that's not me, I never wrote an ambulance. Okay. So then we got to, well, so I asked the attorneys, where did the ambulance pick up? And he said, Pratt Whitney. For those that are from around here, Pratt Whitney, which is now called something else, PCI or something, out towards like Taylor County, Talbot County. Okay. So everybody knows Pratt Whitney if you look around here. Okay. Look at the guy. Sir, have you ever worked at Pratt Whitney? Yeah, I worked at Pratt Whitney. Okay. So did you work at Pratt Whitney on that? We had to go through the whole thing. Not me. Wasn't me. Have you ever been in the hospital? Yep. It was around those days. I mean, to the point where he admitted everything, but the fact that that was him that got in the ambulance. So I was like, look, issue. You may not remember it. It may have been problematic, whatever, issue. So I issued a ruling that he had to pay the money. He was like, I'm going to appeal. Live your best life. Go ahead. But he never did. But those can go up.
How much did he owe?
It's like $3,000 maybe a little less.
So what would be a reason that somebody wouldn't go through the trouble of appealing from a municipal court judgment up to Superior Court? Given what you know about the limit of what you can recover or that you could be found to be liable for in municipal court.
Does it outweigh financially? Does it make more sense to say, Rrr.
Is it worth it?
Yeah, is it worth it?
You're going to have to hire, you don't have to hire a lawyer, but you're going to appeal. Now you, as the litigant, have got to prepare something to show the court what you're appealing from, and you've got to point out to the judge in the Superior Court what the judge in the municipal court got wrong. You can't just show up again and say it wasn't me. So financial reasons, time reasons, things like that might be reasons that you wouldn't do it. I want to point out too, and Amy, correct me if I'm wrong, in Muskogee County, these two courts are really the same, correct?
They really are. We have two different clerk's offices. The municipal court has an elected clerk so Columbus is a consolidated government, so it's a city and a county. But we consolidate the two, but we have a municipal court has an elected clerk, and they have their own office, but it's in the same floor as the magistrate court, which has technically the judge of magistrate court is elected, but also serves as the judge of municipal court.
And the difference would be, if you remember back from our discussion about subject matter jurisdiction in the second week, the difference would just be what kind of cases go in each box. You might have a certain kind of case that you have to go to this court for first, or this court for first. We think of magistrate more as the small claims court, and then municipal court more as sort of local things, violations of city ordinances, things like that. So one thing else that you mentioned is you handle some preliminary criminal hearings, is that right?
Yes.
So those aren't the hearings, you're not having trials judging guilt or innocence.
We can on a misdemeanor traffic offense. We can. So when you are charged with a misdemeanor or traffic offense, you can enter a guilty plea in our court. So let's say you're charged with no insurance. We get a lot of that. Or no proof of insurance. Like, I got insurance, I just didn't have the card in the car. Let's just say it was no insurance. You come to court and say, I want to enter a plea. I just want to be done with it. So there's actually two ways to be found guilty. One is to say I'm guilty. And then we have something we call a nolo plea. It's nolo contendere, it's Latin. Which pretty much says, I don't think I really did exactly what you allege that I did, but I did do close to it. So I want to accept responsibility without saying that I'm accepting guilt. Two kind of different things. Yes?
Is it the same as an Alfred plea?
No. Alfred pleas are best interest pleas. We call it a best interest plea. You hear them a lot in courts with felonies, and usually it's when the state has recommended a sentence that the defendant just refuses to accept, but the defendant also knows they're kind of guilty, and they don't want to go to trial, because clearly when you go to trial and go through that whole process, it kind of starts pushing up on the guidelines of the sentencing where you're going to end up. So an Alfred plea is saying, in essence, it's my best interest to enter a plea. It is in the best interest of me as a person to accept responsibility, even though I'm not going to stand up here and say, I did everything that you said. So it's a little bit different. That's a good question, though. But yeah, NOLO is, I want to take it. So we give you, if you're out, we're normally going to, like you're not in jail. We're going to give you probation and like a fine sometimes. I'm not a big fan of putting people on probation for long periods of time for things that are really statutorily, like mostly it's just a fine. Like if you don't have your insurance, or you didn't have your license on you, or you ran a stop sign and there was no accident, like you just ran a yield, or one of those no turn on red, right hand red lights that everybody wants to turn on red on because it just makes sense. I'm more about, let's give you a fine, let you pay it off. I give you like 30 days or less, pay the fine. Because probation means you have to go to the probation office, you have to pay a probation fee. And when we have to give people large fines, because by state law, there are some things that it's like a bare minimum. You have to pay at least $250 is the lower end of a fine. And just like anywhere else, criminal court has sales tax. So we have, not really, but we have add-on fees. So even a $250 fine, I think it's like $325. So they have statutory fees that get added onto it. So if you can't pay it, I'll give you time through the probation office. But I always say, as soon as you're done paying, you're off probation. Because there's just no point. If I need somebody to be watched for like DUI, let's say you can plead to a DUI in our court. You can put them on probation. You can have all the rules about monitoring them. That's one I'd be more interested in, especially if you've got a history of DUIs, of having you stay on probation for a while so they can monitor you and see if you're continuing to drink and drive. We have all kinds of electronic devices now that can make you, after it's like your second DUI, the state requires you to have this interlock device where you have to blow into it before your car will start.
So everybody nodding that you have those in your car?
Yeah.
That-
You know, we also have, there's also a website company called SoberLink, which we use in, you familiar with that one? Yeah. We use in domestic cases a lot.
I'm not familiar with it because I personally
No, you didn't do it.
Right.
But they have an app where it's a face recognition, and so either at a specific time or sometimes you can make it so it does random. You attach it like Bluetooth sort of to your phone, and face recognizes, and then you blow into the device, and it recognizes whether you have alcohol in your system, and it can send it to whoever is on the email list to notify that you have a negative or a positive test, which has been really interesting in cases where we have parents who are abusing maybe alcohol, where we make them do that before they can visit with their kids, which is sad but true.
So we talked a little bit early on about burdens of proof and how in a criminal case, it's up to the state to prove that the person did it. So in your chair as a judge, you come across cases where you think that the person probably did it, but the state is not proving their case. How do you handle that when you think something that's different than what the rules are saying has to happen?
So at a prelim hearing, it's a probable cause standard. So it's just, it's not beyond a reasonable doubt. It's not the super high burden. It's a probable cause standard. The issues that I have with law enforcement sometimes really mostly deals with one area, and it's driving while license suspended. So when you get your license suspended for whatever reason it may be, people's licenses are suspended for getting arrested so many times for a certain charge. If you're on an order, under court order for child support through child support enforcement and you don't pay your child support, they can suspend your license for whatever reason. But the law also says you have to be given notice of your suspended license. And that's where I've differed with the Sheriff's Department several times, is the way I've read it is notice means you have to actually be served by a law enforcement officer on a piece of paper that says your license is suspended as of this date. So if my license was suspended back in January, but I don't know my license is suspended, and I get pulled over and they charge me with driving while license suspended, how did I drive knowingly on a suspended license if I didn't know it was suspended? So I got no problem with there's a driver's license, no state driver's license, something like that, but I require them to tell me the serve date. So what they do now is if they get pulled over and you haven't been served, law enforcement will serve you the document that says this, and they won't charge you with driving while license suspended, but they also have to note it in the system they all use. So it'll have a serve date. So if it doesn't have a serve date, I won't let them, I have issues with the driver while license suspended. If it has a serve date, then yeah, you knew your license was suspended. So also we get the people who continue to drive on their license that's suspended. Like they're on their 5th driving while license suspended. And what happens when you get charged with things like that is it affects your ability to get your driver's license. So after so many charges, you just need to get a bike because you are not getting that license back. Like it is not gonna happen.
But do you have repeat customers that you look at your list and you're like, oh, here we go again?
Yes. Especially with like kind of what we could consider sort of pseudo petty crime, shopliftings. I get a lot of, then we tell you, most of the time the store gets their stuff back, or at least the property back. So as long as they got that back, we're still gonna put you on probation, maybe pay you a little fine just as a punishment, but they've gotten their stuff back, so no restitution, which is where you're having to pay back what something is worth. But you get the people that they have already been told they're not allowed to go back to Walmart or Target. Like there's nowhere left, Kohl's. Like they're out of places to go because they have shoplifted from so many places. There are also some crimes that are like that, like shoplifting. If you get so many of them in a certain amount of time, even though it's small, they're misdemeanors. I think it's 4 and 5 years. The 4th one makes it a felony. You become what we call a habitual violator, meaning you continue to do the same crime over and over and over again. You are clearly not learning when we give you these little misdemeanor sentences, so now you're going to become a felon. So we see it with DUIs, driving while license suspended, and shoplifting are the big 3.
How much discretion does the law give you in imposing a sentence? Do you have a range of choices?
For misdemeanors, the statutes give us some numbers for fines, and then it says all of them will say punishable by up to 12 months. So anything that has the word months attached to it is misdemeanor. It says years, it's felony. So yeah, we can, and if you've been in jail for a couple days, like if you got arrested on a Friday and you don't get to have your hearing till Monday because that's how ours are, A lot of times I'll give you credit for that if it's not one that I have to give by law a fine on. If it's can be punishable, may be punishable, then I'm not gonna worry about it. Some of the statutes require a fine, a bare minimum fine. It can go up, but most of them say it's discretionary.
So when you sentence somebody, there are really two components. There might be something that the law says you have to do.
Correct.
And then there also might be a part that the law says you could do.
Yes.
You come up with any really creative sentences for anybody yet that are sort of out of, or do you have discretion to do that?
Yeah, well, this was not creative, but it was something. We had a lady the other day. So there was a fair in town, the spring fling down at the Civic Center. So she worked with the fair, so traveled around. And she and her boyfriend got in a slight altercation at the Civic Center outside of their trailer. So the law enforcement got called, sheriffs got called, and they said, look, we're not gonna charge you. They gave her like a citation for, I don't know what it was, something. But they said, but we're not gonna charge you, you're not gonna take you to jail, just get off the property. You gotta go. She got off and then came back later that night. And so when they tell you to go and you come back, it's trespass, it's criminal trespass. So law enforcement came back and she got arrested this time and then went to jail and sat in the jail overnight until she came to court the next day. We were virtual and she wasn't from here. There was, like, she had literally no ties here. Her ties were to this traveling fling or whatever they call it. So my sentence was, she couldn't go back to the Civic Center. We told her that they had to pick her up at the gas station across the street. Like you cannot go back on the Civic Center city property. You can't do it. But we gave her like some credit for the time that she was in, plus a sentence that kind of got her out that evening because of the way the jail calculates time. It's not always hour for hour. Sometimes it's 4 hours for 1 hour because they don't need people in there taking up space for small things. So we just said, you can't go back. You got to be across the street. But I'm not going to put you on probation for this because you won't live here. I'm not going to give you a fine because, we're for fair. So
the jail sometimes on their own plays loose and fast with the definition of a day?
Yeah, that's correct. Sometimes they give it, most of the time they go, we call it 2 for 1. Finish for every day you're there on a sentence. If you're being held there or awaiting trial, that does not count. Normally. But if you're there and some judge gave you 5 days of a sentence, usually about 2.5 days in, you're out. Depending on how full the jail is, sometimes it's like 3 or 4 days for one. Because they just want them out.
Virtual court.
We do virtual prelims. The people at the jail are literally at the jail. We have, I don't know if you've ever been to the jail, but in the back, the jail has 2 courtrooms, which are always in use between prelim hearings for recorder's court and guilty pleas and state court and superior court. So in the back, they have set up a AV room. So we have the AV room in use. That's where all the people are that are at the jail. Our public defender is actually at the courthouse. So in the morning, he goes to the courthouse. They have a separate setup so he can go back there, like virtually. He talks to all the defendants for that morning, and then they come in one by one after we read in their rights. And we have the lawyer in the courtroom, the judge in the courtroom, the defendant in the jail, and law enforcement in the courtroom. It's a little weird.
Do you like virtual versus in person? Do you have a preference?
I don't hate the virtual for criminal stuff because our courthouse is several blocks away from our jail, and to transport everyone there in the morning, it's a lot of back and forth for that. And there's holding cells down in the tower, so I don't mind it for preliminary hearings because those go pretty fast. What I had an issue with is I had some lawyers who wanted to appear virtually, but in civil cases, but the parties, usually a defendant, was in person, and it created a lot of problems. These were a lot of these credit card collection cases, and so the lawyer, what used to happen, pre-COVID and then now, because I stopped it, is the lawyer for whatever companies that day that were there to collect on their credit card cases would be in the courtroom. All the defendants would be there for whatever time they were noticed for. They would be able to have a conversation. 95% probably of the time, once the lawyer talks to the person who owes the money, they work out a consent agreement about how much they're going to pay. They're like, yeah, I owe the money. Okay, so how much can you pay per month? You know, it might be $35, might be $100, whatever. So we sign off on those. But when you're on the computer, the person is here, and the people will be like, I don't have my cell phone, I left it in the car, I didn't think I could bring it in the courthouse. Well, how are y'all supposed to talk to each other? It makes it a lot more difficult to have communication. So hearing times that would usually take us an hour to get through 20 hearings because they all come to consents would take us 3 hours because it was too much of that. So we stopped that.
So I want to just go back for a second. When we talk about preliminary criminal hearings, you remember there's several steps in a criminal process. You'll go to court to hear the charges that are against you. You'll go to court to enter a plea. Those are all what we're talking about preliminary hearings, where you'll go to court to see if there's going to be a bond that you'll have to post to get out of jail, whether they're going to hold you without a bond, those sort of things. And those usually happen pretty fast up front. If you're going to actually go to trial on your criminal charges, that's pretty far down the road.
Yeah.
But when we say preliminary, that's not the hearing where the judge or a jury is determining whether or not you're guilty or innocent. These are just the preliminary steps. So I can keep asking questions, but does anybody have anything so far? Miss Allen? Good question.
Okay, so I would give you background. My undergrad degree is in music. I have a music education degree from Columbus State. I was a flute, piano, and tuba player. I started playing when I was 5, played piano when I was 5, played the cello when I was like 11. I played everything. I was a flute major. And I've told Tom as we were walking in, the outside, remember we were in the building over here, this space between these two buildings, that used to be a driveway. You used to be able to circle around, we called it the horseshoe back then, because back then the building right across from here was the music building. It was music, art, and theater were all in the same building. Okay, so senior year in college, I was going to be a music teacher. I took all the tests, everything's good, I passed. And then I said, well, I'm gonna take the law school entrance exam. Why not? A friend of mine convinced me to. And I don't know why I did it. But I think I got personally terrified that I was going to be a music teacher for the rest of my life and be like in an elementary school teaching 3rd graders whole notes and half notes until I was like 55. And because you can retire 30 years. So I went to law school, which was interesting. So I went to law school at Loyola University in New Orleans because I applied for 4 law schools. And I applied late. I didn't know what I was doing. I had no clue. Applied late, got into 2, and it was either New Orleans or Jackson, Mississippi. And I picked New Orleans because who wouldn't? So Louisiana is also an interesting state because they still follow what's called the Napoleonic Code, literally Napoleonic Code. So their civil law has different rules down there. But they clearly have lawyers from all over the country that come in that take what's called common law, which is everybody else. So I was a common law student, graduated in 2004, and then came back here. My first job was working as a law clerk to one of our Superior Court judges here, who passed away several years ago, but was a Superior Court judge, was a district attorney, all of that. And as time progressed, I had an interest in kind of moving to being a judge at some point, because it's interesting to hear it from the other side. Like, I'm used to one-sided, like my side. Like, I'm going to argue when I'm going to argue, or I'm going to be there for whoever I'm going to be there for. And you don't always think about the other side. The other side is just always wrong when they're not your client. When they're not your, am I right? Yeah.
Well, that's your job. Your job is to advocate for
right, that is your job. So I was appointed as the associate magistrate in April of 2018 by our current sitting chief magistrate, who's Judge Steve Smith. And I do believe I almost vomited the first day that I had to go on the bench because I was so nervous, because it's very different. And you think that when you're sitting there as a lawyer that the judge is listening to you and that the people around you are listening to you, but you really don't know that people listen to you until you're sitting up on the bench and you're wearing the little black robe and everybody's listening to you. And so you have to be more careful with your words. You have to really think things out. Like, I will write out sometimes if I'm having a hearing and I'm going to make a ruling from the bench about, again, smaller type claim cases. I'll start kind of handwriting out what I want to say. Sometimes, if I feel like there's some contention in the courtroom, I will take it under advisement, meaning I will say, I'm going to send down an order later because I don't want people to get upset in the courtroom. I don't want to make it any worse than it is. But I guess the question was, what made me want to do it? I think I wanted a different outlook, and it has given you a different outlook. I do think about cases differently sometimes now. Like, how is this going to play? If I were the judge up here looking at this, what would I want to hear? Do I really care in a custody case about the fact that you let the child watch 2 hours of whatever is on TV now? I don't know. And she only let the child watch 1 hour. No, I don't care. I care if somebody's taking care of a kid. So I think I look at it in a different perspective now, which has been helpful for my actual law practice too. Because I do a lot of guardian ad litem work, which is I do custody investigations and I represent the interests of children in divorces and custody, probate cases, to make sure a kid is taken care of. So I kind of have to look at it from both sides a lot.
I hear a lot when you have these panel discussions with judges who are giving lawyers tips or whatever.
Yeah.
The number one thing I always hear is get to the point.
Yes, get to the point.
Get to the point.
I let them go because the majority of people that we deal with are pro se, meaning they don't have lawyers. Most people in our court don't have lawyers. On non-criminal things. Criminal things, they have a public defender. But I will let you go for a while. But there does come a point where if we need to talk about the color of the vehicle at issue, and you're telling me what kind of bike you rode at grandma's house in 1983, I'm gonna need you to come back. And so I've had it. So you kind of have to also move everybody back to, okay, well that's great, that's interesting, but let's get back to and then you ask some questions. Because the court can lead you sort of to the area I need you to talk to me about. Like, talk to me about blank. Like, when did you find the leak in your basement? That's the question. And especially people that don't have lawyers, sometimes you have to kind of help them get to the information. And I will ask questions. And some judges from any of these, well, not those two, but these 3, 4, that group, they will not ask questions. They'll just let the lawyers, especially if there's lawyers, do their job. If it's a lawyer on one side and then a non-attorney representing themselves on the other side, they'll let the lawyer do all the questioning. They won't, not that they won't listen to the pro se person, but they just say, tell me what you want to tell me, and that's all they'll take. I will ask questions, because sometimes I want to know the answer, because that's going to help me figure out what's going on. And I'm trying to get to the actual information. I'm not trying to say one side's better than the other at that point. I just need to know all of it before I get there. So.
Mr. Singer, I'm sorry, you have a follow-up, Ms. Allen?
Yes. Which side is more time consuming? I know you say you did the other side too. So which one is more time consuming? And if being a judge is more time consuming, then how do you find balance with living your personal life and
What personal life? No. My personal life right now is that I'm having to live in an apartment because my house was infested with mold and asbestos. That's been fun. It's like back in college, but legal. The part that I do for the judging is considered part-time. So the majority of things that I deal with are Tuesday mornings in our court and then Thursday afternoons. Sometimes I have to cover other things, preliminary hearings, or Monday, Wednesday, Friday at 9. And it's a balance sometimes between that schedule and my regular practice schedule. I have been lucky that a lot of lawyers here have been really helpful and agreeable. Yeah, I'm gonna be late, is that okay? That's fine. We tell the judge will be like, that's fine. So most of the judges have been in Superior Court, have been really gracious and helpful as well. It is a balance, I think, but I think it's a balance not just for somebody that's a part-time judge, but somebody like you, Tom, that's teaching a class here and has a full-time practice and has a home life. And I will say that is a big thing that they talk to lawyers about regularly, especially when COVID hit, even more so, but even before that, about having a balance. And I think that applies, it doesn't matter what your career is, but having a balance. Like, do you read your emails at night? Sometimes. Depends on who it's from. But it just depends on who it's from. But no, I mean, I have to have a moment where I need a break from all of it. So there is that's something for everybody, even college students. You got to have some kind of balance. There come a point where you just mental health break. And we are big fans of mental health break. Take the day off. Take the afternoon off.
George.
My question was already sort of answered. I was curious as to what her major was when she was here.
Gotcha. All right, who else? Sammy.
So Mr. Diego kind of, President Diego kind of mentioned, and you kind of talked about a little bit how you specialize in a lot of cases with children.
Mhm.
How does a judge specialize in a certain type of case? Because you also talk about how you do a lot of different kinds of cases.
So my judgeship is just in Magistrate Municipal Court. That's the only thing I deal with. My law practice is completely separate. So, and that is mostly in Superior Court, well, Superior, Probate, and Juvenile. So they are completely separated. I cannot take any case in Magistrate or Municipal Court as a private attorney because I'm a part-time judge there. But in most of the cases here, you don't deal with that kind of stuff. Like anything dealing with children or custody and divorce, that's all relegated to one area. The Superior Court, and then sometimes Probate Court a little bit. So, completely separated out. But dealing with children is its own little special area of law.
And so here's how that happens.
Yeah.
Let's say that I represent mom who comes to me and says, I want to get divorced. Dad, most of the time, has his own lawyer. There are minor children. They can't agree on who's going to have custody of the children, or how the children are going to visit back and forth. Often in a divorce, one will say, well, it's not safe to be over there, or this parent has a substance abuse problem, or has some violence problem, something like that. So in those cases, if it's really contentious and there are some issues that truly need to be investigated to a degree that a judge who might hear the case every so often, that judge can't really investigate or get a full picture. And so in those cases, the judge could appoint what's known as a guardian ad litem. That's a lawyer for the children. And then oftentimes the parties' lawyers themselves will say, hey, I'll call the lawyer and say, listen, this is a case where we're going to need to have a guardian ad litem. And so when the guardian ad litem is appointed, they will investigate everything. They'll talk to teachers, they will go and visit homes, they'll talk to relatives, they'll talk to coaches, they will talk to counselors and doctors if necessary. And then their job at the end of that investigation is to make a recommendation to the court as to what they think is in the child's best interest. So there's a little bit of a distinction. They are a lawyer for the child, but their job is to make a recommendation on what's in the child's best interest, not necessarily what the child wants. And I always say, if you ask a child, if they would like to eat ice cream for every meal, they would say yes. Well, that's not obviously in their best interest. So that person is doing a whole investigation, and they're telling the court, I think these children should live with this parent. They should visit with the other parent these days. They should have this many weeks in the summer. They should split up Christmas this way. Those are the most headache parts of the job. But it is an important job because you know, when we're dealing with children and custody issues, the stakes really can't be higher than that. And so, so with that introduction to sort of how that happens, Amy, if you want to add anything to kind of what you do as a guardian and.
I would talk to all the parties, talk to the children, go to schools, interview teachers, talk to mental health caseworkers, like if they have a counselor. Sometimes I have to have a conversation with an actual doctor, depends on the case, if there's issues. We have a drug testing lab in our courthouse here. We have a drug court. For those that don't know, we have a very well-respected throughout the state drug court here. So people that are charged with certain charges that are clearly having issues with drug abuse, they can enter into our drug court program, which is pretty much a minimum of 18 months. There's 5 phases to it. But, and if you get to the end of it and you have remained sober, and they have all kinds of programming that works with you, they have counselors, they have like inpatient facilities, they have outpatient, it's a great program. But they have a testing lab. They created part of this court because people will lie and say, no, I did not snort any cocaine last night. But lo and behold, if you test them, they did. So they created this lab, which the domestic attorneys in town went, well, you can test people with drugs? Okay. So now we use it. We can also test people for alcohol. So your hair, if we take your hair, it doesn't have to be the fall, it's not the outside. You can color it all you want to. We take your hair, it's cut, it's not pulled from the roots, it's literally inside the hair. They can test for all kinds of drugs. The big ones are amphetamine, methamphetamine, cocaine, benzos, which are like Xanax, marijuana, trazodone, I don't even know why that's on there. And we can also test for alcohol. And it goes back about 90 days, give or take. We also can do urine tests. You can urine test, depending on the drug, 24 to 60 or so hours. You can also test for alcohol. My favorite was the guy one time who admitted later, his hair follicle came back positive for a lot of cocaine. And then his urine came back positive for cocaine and marijuana, and he told the judge later he smoked the marijuana before court so he could calm down. So that was, all right, fine, that's fine.
That's
So,
not a horrible explanation.
it wasn't. It was not. It was a valid explanation, but he was not in a good place. So this is so drug screens, alcohol screens. We have the number, the cutoff number. It's a lab cutoff. It can go high. I had a guy one time that came back greater than for meth. Greater than. And then he tried to tell me that the meth was in the drywall that he was putting up in a house. It was not. So you get all kinds of stories. There was a lady who said the meth was in her dog's fur. The lady that said that the meth flew onto her hair when she hugged her daughter, who indeed did do meth, but apparently so did mom. Because it's in the hair. It's not on it, it's in it. So when we test you for drugs, we test you for alcohol. So I don't know how old y'all are, but we'll pretend you're all 21 and up. You're old enough to drink. It's fine. Have a couple drinks. If you're under a certain amount, it doesn't even show up. And it may not be that, it's not that you're not drinking, you're just not drinking super regularly, so it's not showing. Anything when the number is 20, so above 20, okay, you're drinking maybe a couple times a week, maybe a couple beers, a couple glasses of wine, 3 maybe-ish average times a week. Okay, so we start to kind of see it. Above 50, it starts to show more chronic abuse. So you're drinking more, or you're binge drinking several days. So there's about 3 full-time that we do almost all guardian ad litem work. I do, not all, but the 3 of us, there's three people. So we have a kind of a running text group that says, what's your highest score? And it's horrible, but it is. So their last highest score was 168. Cutoff is 20, over 50 starts through chronic abuse, 168. And this gentleman his dad, admitted in court that he drank 6 to 8 drinks a night, and then told the judge he could try and cut back if he had to. So, he was trying to take one for the team there for his kids, because he was drinking so much that it was affecting his children. Another one came back, another attorney came back, said, "No, I got a high number a couple weeks ago, 230 something." This guy was drinking even more than that. But I came in with a new high number last week. I had a dad who had equal time with his child for years. They alternated days and then every other weekend. It's a horrible schedule. But he had his child half the time. Swore up and down to the court, to me, everybody, I never drink when I have my child. And I have my child half the time. 644. Yes, that's the same response I had. That was his alcohol screen. The cutoff in urine was 500, 7,000. And I said, "Did you drink last night before we had this hearing?" And he took the test at 1:30 in the afternoon. And he said, "I drank." I said, "What'd you drink?" "I had like a couple of malt beverages from the liquor store." I don't know what that is. I don't really, with the Four Loko, what is that? What is a malt beverage? That was Four Loko back in my day. I'm surprised we're still alive. But he swore he didn't drink. So that gentleman is likely going to be on, he's going to get to visit with his child, but because that's a really high number, the court is going to err on the side of caution for a child and say, "Look, you're telling me you don't drink when you have this kid, but I don't think it's feasible for you to get this high without drinking fairly regularly." So the sober link, the things that we talk about, we have to breathalyze, he will have to probably spend several months with any visit he has, blowing in at the beginning, blowing in several hours in, to see if he's drinking, because he says he's not. I don't know if we believe him. Do you believe him? Based on what I've told you, the facts scenario, who says absolutely he's only drinking half the time? Who thinks there's no way on God's green earth that he can get to that number by drinking half the time? Some hands. Yeah, I get the point.
I'll say too that very often in custody cases, each parent wants to have more custody of their children than another parent. That's natural for a parent, right? You want to be with your children as much as you can. There's nothing wrong with that. But you have a real disincentive to be honest about some things. If my wife if she and I are going through a divorce and we're talking about custody of our kids and I've got a drinking problem, if I go into court and say, "Yeah, I've got a problem, I think I probably need to go to rehab," well, that gives her the advantage in the case right there. So I'm not saying it's right to lie or that this gal was right. This is an extreme example, but the incentives and the stakes are so important for parents and that kind of thing that it's really, everybody wants to put on their best face for the guardian ad litem and for the court. I mean, to admit weakness kind of, as a parent, you feel like that might undermine your custody case if you admit any weakness. Flip side of that is it makes parents point out every single flaw with the other parent that they can possibly think of.
Right.
Because they think it's like a scoreboard situation. This is the custody case, and I want to get as many points as I can, and I want to say as many bad things about the other parent. I always used to say, it wasn't an issue when you were married for 15 years.
Why is it an issue now?
All of a sudden it's an issue now. Any more questions? I will say something interesting that I've seen in that area is that we can probably all agree that methamphetamine use by a parent would be dangerous to the child. That'd be problematic. Alcohol, on the other hand, is much harder because, first of all, it's legal. It's not illegal to drink alcohol around your kids, thank goodness. But what we're looking for, I don't want to scare y'all and think if I go into court, if I, drink beer.
No.
We're looking for patterns of abuse or a usage or behavior that creates danger to kids. So that's kind of the end of the spectrum. You've got these really dangerous drugs, and you've got alcohol, which is, is again legal and very common. What I've seen, and be interesting to see if Amy agrees, is that 10 years ago, marijuana use was treated much more like methamphetamine than alcohol. And a lot of our judges were older white guys who would say it's illegal. It's against the law. A parent who is breaking the law is not by definition, but that's some pretty good evidence that that would be bad for them in a custody case. What I'm seeing now is that the courts are saying, okay, marijuana use, you're gonna have to show me now how that affects the ability to parent. Or what behavior can you point to that shows me that that marijuana use has caused danger to the child? Do you
I do.
see that?
So for both of my, so as a judge, if you come in front of me and you are charged with possession of marijuana, you have technically committed a crime because it is technically illegal. Now, our law enforcement's not really given a lot of like citations now or arresting you for misdemeanor marijuana possession. But if you have all the other drugs and then a little marijuana, they're gonna add it in. But technically, it is illegal. You can be charged with it, and it is a crime. Now, because you had it physically on you. I mean, they caught you. It's not like you just had a whiff of the vapor. You know, like you literally had it on you, you're caught with it. As a guardian, if I get somebody that tests positive for marijuana, I want to look at the whole circumstance. Is it just marijuana? We have had a lot of issues lately, not issues. Delta 8 products, y'all know what those are? I'm gonna take a guess, yes. So the gummies, a lot of our labs, while very good because of how close the chemical components are for Delta 8 to like true THC, it's one like compound off. It's testing positive for marijuana, for THC. So I get a parent that'll say, look, here's the stuff that I have. I bought it legally. You know, you can buy it at a gas station. You can buy it at a nice little healthy food place downtown. You can get it everywhere. But here it is. Well, it's testing positive for marijuana, but this is probably what it is. So we are having a harder time now as to whether it's true marijuana, whether it's Delta 8 products, and then whether it really is impacting your ability to take care of a child. I have known in my adult life lots of people who would partake in marijuana of some type in some fashion, but have functional, professional jobs and do their job and have children and their children are well cared for. And is it impacting their ability to parent? Now, if you're doing meth, it's going to impact your ability to parent. I can go ahead and tell you right now. If you are abusing alcohol to an extreme, it can affect your ability to parent. So we're looking more, when we see both alcohol and marijuana, is it really making a change? Like what's the effect on it? Not just, well, you tested positive for it, so that's it. You test positive for meth or cocaine, or with the one guy who tested positive for everything once, literally everything. It's a good time. So that's when you got problems. You know, meth is not, you can't grow that. There's no product that has a variation of meth. People will tell you all the time. My favorite was a lady who said it was her Afrin. Her Afrin spray made her test positive for meth. Now, I will say this. There are some very specific drug interactions that can show a positive for meth without being meth. They are extremely limited and rare. And we have a test for that. There is a test where they can separate out the methamphetamine to what they call D isomer or L isomer. L is the legal, that's how the doctor explained it to me, L for legal. So L are the legal isomers, D are the illegal isomers, which is like the breakdown, I didn't do chemistry, components. So if you break it down and they come back and it's L, they're like, okay, no, legit, this is a false positive, this is why. Comes back D, nope, you did the meth. So there are ways that, I guess if you're doing it, we can support, catch you is not the word I want to use, but we can find out in a lot of things. But yeah, marijuana is becoming interesting. I think the House passed a resolution, a House, the Congress is trying to pass to legalize marijuana, and not to get into the federal versus state. I think you heard that already. But even if it's passed in Congress, that legalizes on a federal level. The states can still do what the states want to do with it. So,
Interesting. So, yeah, I had a lady one time that tested positive for amphetamines and she blamed it on cold medicine. The problem was that her level of amphetamines meant that she would have had to have taken 50 boxes of cold medicine. So that kind of undercut that. I got a couple other questions, but I want to give y'all a chance. Who's got a question? Dalton.
When you're hearing a case, what's your process? Say it's like one side against the other, one saying one thing, one saying the other. What kind of process do you go to, like, figure out who's telling the truth, or if they're both telling the truth, or what? What's the...
sometimes they both are telling the truth, and then it's a matter of balancing what their truths are. It is, nobody teaches you how to be a lawyer or a judge in law school, just honestly. They teach you how to research and write. So, am I wrong?
That's right.
Okay. So, it is sometimes a balance. Like, well, this is true on this side, so maybe they weigh up a little bit, and it's just like this. You kind of have to go. Sometimes I try to find the middle ground. Like if we're hearing a case about a money issue, like if I paid them this much, but I want all my money back because they didn't do it right. Well, it turns out they did 50% of it right when we kind of get down into the nitty gritty of it. So, but they did 50% real bad wrong. So I'm not giving you all of your money back, but I do think there was, under the contract you could get some money back. So it's kind of figuring that out sometimes.
Sometimes people believe something that's wrong.
Oh, absolutely.
That's their truth.
Sometimes lawyers believe their clients and they're wrong.
Yeah.
There's the lawyers that will go like headstrong. My client can do no wrong. They have told me all of the truth. I believe every word out of the mouth. And they get to court and it turns out the client be lying. And lawyers withdraw sometimes after that because, but you got to know, when you start out, you believe everything your clients tell you. My clients are wonderful. They're amazing. Great. And then about 2-3 years in, you go, everybody's lying to me. So I start from there. Not that everybody's lying. But I start from, you got to prove to me what you're telling me before I'm going to go tell somebody else this. Like, prove it. You got the screenshots. You got the messages. You got the whatever. Prove it to me before I go off and start arguing with a lawyer. I want to know that I can support my theory and not just that I'm just out there yelling about it.
Yeah, and as a lawyer, we go in front of the same judges all the time.
Right.
And so if we go and we push a theory or an idea that's just ridiculous or not true, then the next time we go in front of the judge, then that judge thinks, I don't know that I can believe everything Mr. Tebow's telling me.
Right.
Because in the past, he's come up with some preposterous stuff. I will tell my clients all the time, I am not saying that. If you want, that's the argument you want to put forth, or that's the theory you want to push, then you'll have to find another lawyer, because I want the judge to know when I say something that Mr. Tebow, most of the time, I hope most of the time, backs up what he says.
And lawyers have a way of telling a judge without telling a judge that this is the client and not the lawyer. And usually it starts with my client's position instead of our position or my position. And
we believe.
Yeah, and it is my client's contention. My client is, so it's that key phrasing in the way you do it where a judge goes, okay, it's not you, it's them. So they understand we're doing what the client's telling us.
Raven, you have a follow-up?
So if you were to get in trouble, you personally, if you were to get in trouble for anything or, I guess like violate the law, will you go through the same process as like I would?
Mm-hmm. So let's say, okay, for example, I got a ticket. Legitimately, I was totally in the wrong. So I was driving to coach my high school mock trial team, which was the irony of all this. And I get pulled over on 2nd Avenue going out. I was on the phone with another lawyer at the time. I said, I'm getting pulled over. I said, what are you getting pulled over for? I don't know. So I'm gonna stay on the phone. What are you gonna do from the phone, Betsy, but whatever. So fine. So stay on the phone. Officer pulls me, very nice gentleman, comes up to the car. He's like, he told me who he was, pulled me over, CPD. because it showed that my registration wasn't updated, wasn't valid. And I said, okay. And so I said, can I always ask, can I open the glove compartment? Yeah. Pull it out. I have like 6 years worth of registrations, but I don't have this year's. And I was like, you're right. I don't have it. So he said, I'm going to write you a ticket, but if you come to court with the valid registration, we'll dismiss it, which is what they do a lot of times with those. Like, it's something that's easily fixed. If somebody forgot it, mailed the wrong house, whatever. So, okay, cool. So he said, make sure you're not to miss the court date. I was like, I got it. I'll make the court date. So the next morning, I take my little self over to the Publix, which, by the way, has a vehicle registration thing in there. You can do it, and it costs an extra $2, but perfect. Got it all registered. So I showed up for court a month and a half later. Sometime last month. And I sat there over recorder's court, my phone, kind of waiting to the end. They called me last. I don't know if they did that on purpose, just because, but I didn't care. And so then I pop up. And this is the judge I practice in front of sometimes. I was like, hey, judge. So I handed my new registration to the officer, and he said, she's got the registration, dismiss it. So, yeah. If you got pulled over for the same thing, he'd give you a ticket. He's not going to arrest you for that because nobody got time for that. Like, they don't have space in the jail for that. That's a citation. If I had not gotten it fixed, or if you had not gotten it fixed by the time of court, they were probably going to give you a fine and some probation because you had all this time to fix it by that point. But we also, if we get arrested or charged with anything, we have to report it to the bar. I don't think I had to report I didn't report because it got dismissed, my ticket. But if we get charged with...
We could face discipline.
Yeah, we can face discipline from the bar.
Outside of the criminal justice system.
Yeah.
Most of y'all probably know this, we had an elected district attorney in this circuit who took office in January of 2021, and he did not make it to the end of the year before he had been arrested and charged with crimes. And was he tried last year or this year?
Last year.
Last year. So he didn't
He
even
went in
make
October.
He took office in January 1, 2021, and was in prison by the end of the year.
Still there, I think.
Still there, yeah. So if anybody has other questions for Judge Walters, come on down and ask them after we're finished. If you're from Judge D'Antonio's class, come
Okay.
down.
I'm supposed to tell you if you're. Oh my God, you take a list.
No, go ahead.
If you're in Judge D'Antonio's class, bless you. But if you're in Judge D'Antonio's class, the answers to all of the questions on the final exam are true. That's
No,
what he
the
told me.
property exam.
Whatever. Whatever test he's giving you, he's told me to tell you they're true. I'm just telling you when he told me to tell you. But yeah, if you're from his class, he'll sign up something so he can keep notes.
Come let me
giving you
know and I'll
credit.
let him know. Y'all help me. Thanks, Judge Walters. Thank you so much. All right, we'll see everybody on Tuesday. We'll do contracts again next week.
Oh my God.
Yeah,
I
yeah.
hated contracts in law school.
Uh,
But I can still sign these really good perpetuity.
It's probably the most important thing that we do in here, I think. Not an employment, you know.
If you want somebody to talk about that, you can come next time.
Let me tell you what Maxine did to me.